Hello, everybody. Welcome to our panel, which online platforms should be regulated under Article 25 of the DSA. In this table, we gathered experts on dark patterns under the DSA and representing very different expertises, background, and experiences. So we have, from a regulatory perspective, ARCOM, represented by Jeremy. We have academic expertise represented by Nataliia from Inria. We have policy-making expertise represented by Martin from the Federation of German Consumer Organizations. I do not dare to pronounce the name in German. It's too complicated. Can you say it?
VZBV.
Which can be read VZBV. And we have the civil society represented here by our renowned expert, Katarzyna, head of Panoptykon. And the goal of our panel is to discuss how online platforms are regulated under the DSA. And I brought you some slides to give you a little bit of context of what the DSA says about dark patterns. So Article 25, number 1, prohibits dark patterns. What does this provision refers? It prohibits online platforms to design, to organize, and to operate their online interfaces in a way that deceives or manipulates users, either end users, consumers, either business users, or in a way that distorts their free, autonomous, and free, autonomous decisions. But regarding Article 25, number 2, this prohibition does not apply to practices already covered either by the UCPD, either by the GDPR. And this triggers questions which practices are actually covered by this Article 25. There are big hopes regarding this article. And what are the responsibilities and the obligations impending over these online platforms? And these are the answers that this panel will provide, hopefully. I also want to give you some more context. Recital 67 and Article 25, number 3, refers to very concrete practices. And in our work, I leave it as here in a footnote, specifically addressing this topic that we will publish in the next few days, refers to certain practices that we map in our work to dark patterns practices, so that everybody can understand what they mean. And this prohibition forbids, for example, prominent choices, so certain choices that are made prominent in regarding to others. This is a very concrete example of false hierarchy. Prohibition of nagging. Everybody knows nagging. There is no need for a definition. Prohibits making certain choices more difficult than they should be. Obstruction, but also known as roach motel. And in our ontology, we also call it creating barriers and adding steps. And finally, it prohibits bad defaults that are very difficult to change. Of course, we hope that the European Commission will provide further guidelines regarding these practices or even others, and we are here to help the Commission further. But let me give you a little bit of more context. The European Commission started already investigations and formal proceedings regarding certain online platforms. And this is the case of Meta's Instagram and Facebook services. And investigations are running regarding deceptive ads. We need to wait and see, actually, what the investigations say when the decision becomes public. And from last year, December of 2023, the Commission actually started formal proceedings against X, so ex-Twitter, specifically regarding the blue check marks that refers to paid subscriptions. I don't know if you are aware of, but these paid subscriptions implies the payment of more or less 8 to 10 euros. And it seems that X made use of these blue check marks for specific celebrity accounts. Certain celebrity accounts allegedly use these blue check marks without paying for them. And we think that the X made use of a dark pattern of social proof to entice other consumers, to entice users to pay for these blue check marks. Let's see actually what the further investigations say. So let me introduce you. It's time for it. I'm Cristiana Santos. I work at the School of Law of Utrecht University, where I do research on dark patterns, data protection, and online tracking. And I would like, without further ado, to introduce you specifically to our Starlight panelists. And I will start with Martin. Oh, sorry. Martin. Martin is a lawyer. He's a member of the VZBV, that I do not dare to say the German name. And Martin, I have prepared some questions specifically for you. VZBV sent several formal warning letters to several online platforms. And you also audited, in December of 2023, several online platforms.
Yeah.
Could you please explain to us who were those online platforms? What were the findings of these online platforms?
Yeah, thank you for having me. Thank you for the invitation. My name is Martin from the German VZBV. And maybe 2 words on our organization. It's a bit special because our organization consists mainly of 3 pillars. As a lobby organization, we represent the interests of consumers with position papers, with our policy work. But we also have the privilege that we have an own market monitoring department. And this evaluation I will show you in a minute is from our monitoring department, and they can conclude investigations, evaluations, and we have in Germany we have all the regional consumer organizations, and they have a kind of network, and that helps us with evidence, and as we all know, we want to have an evidence-based approach when it comes to our work, and so that's our method to get this information. But on the 3rd pillar, we have also an enforcement team, and law enforcement team with lawyers, and these lawyers then can finally carry out corresponding legal actions as well. So we have all these 3 pillars, and so we hope to then really get more into details when it comes to new regulation. How effective are they in reality? And that's always the question, because theoretically they sound really, really good, like, for example, Article 25, and now we have to check if it stands the reality test. So,
Green, to proceed.
Okay, our evaluation did not only consist of the dark patterns regulation in Article 25. We also looked a little bit deeper on the terms and conditions of the platforms, and also we looked into the transparency regulation when it comes to online advertising. But today we are interested in Article 25, and then the question is, what are our results? As you can see here, the overall result is that the providers failed to comply with the prohibition of dark patterns.
All of them?
No, not all of them, and not every time, but at certain provisions I will show you in a second. And they still design their website interfaces in such a way that, in our view, consumers are deceived, manipulated from making free decisions. And these were all cases that we also sent out to the Commission and to our national authority for further investigation. And not only we did something like this, also from other consumer organizations in Europe, under the umbrella of BEUC, for example, not for example, but under the umbrella of BEUC, also filed complaints to the national authorities when it concerning Article 25, but also other provisions of the DSA. So then very briefly I will show you the patterns that we saw after 100 days. So the DSA was already in force for over 100 days, and then we said, okay, maybe they have now enough time to follow the rules, and we found quite typical examples like this. This example. Yeah, this example of Amazon. You can see here that they use this striking yellow to highlight the button to conclude a Prime subscription. So this is very typical, and we consider this as a typical dark pattern. Mm-hmm. But not only Amazon does things like that, we also found something here at YouTube. We orientated these dark patterns on the examples of Article 25, paragraph 3, A, B, and C. This is an example for paragraph 3B, and then that's the in German. Excuse me for this, but this is this playback history. You can activate or deactivate this personalized history. And YouTube asks you over and over again to make a selection. This is for us the typical case for this dark pattern. And the last dark pattern I will show you is the one from Booking.com. This is the one which deals with the problem that it is that the procedure for terminating a service is much more difficult than subscribing to it. Mm-hmm. And here you can see that users have to navigate through a confusing menu to delete their account, but you also have to select the reason why you want to delete the account, and it's, as always, it's pretty straightforward to register, but it's very hard to delete this account. And we believe that this rather subtle tricks can prevent consumers from acting on their desire to delete the account. And then, but I think I will do this at a later, maybe on another question. Then I would like to talk a little bit about our formal warning that we filed to Temu. And this is a file we settled recently, and maybe it's interesting to hear why we think
2 weeks ago or something like that.
Yeah. It's interesting to hear why we think this is also a relevant dark pattern.
I would like to ask you, Temu's practices are commercial practices. So could you elucidate the audience about why Temu's practices using the dark pattern of scarcity, why is it scoped under the DSA, Article 25, number 1 and number 3, mm-hmm. and not under the UCPD? So what makes it special, mm-hmm. since it is also a commercial practice, and how is the interplay between these two legislations, since they exclude each other mutually? That's the elephant in the room. We think it is a commercial practice, and the scope of Article
of the UCPD is opened with this dark patterns that we see here, but then you have to look a little bit more into detail and between the relationship between Article 25 and the UCPD. And in this respect, we follow the position or the assessment of a German project. It's the Dark Pattern Detection Project. It's from Professor Martini from Speyer and his team.
The project, right?
Dark Pattern Detection Project. DPDP. Mm-hmm. And our assessment when it comes to dark patterns is based on their work on Article 25. They published their work in last summer. And sure, if you take Article 25, paragraph 2 at its word, you could argue that the applicability of the UCPD or the GDPR already blocks the prohibition of Article 25. But if you argue in this direction, this broad interpretation would have very far-reaching consequences for the application of the DSA. This is because, as we think, most dark patterns are directly related to the promotion, sale, or supply of a product, and are therefore to be classified as commercial practices. Mm-hmm. And we take the view, if the commercial reference of a design alone, only the commercial reference alone, would be sufficient to block Article 25, the prohibition would be largely deprived of its substance. And this would, from our perspective, lead to, for example, a quite absurd result that, for example, Article 25 would only be applicable to B2B, to business-to-business commercial practices, because these practices are not included in the scope of the UCPD under Article 3. And then we would then have the result that we have stricter rules and better protection concerning dark patterns for B2B, for B2B practices, and we have lower standards than for B2C. So from this standpoint, this also already makes no sense for us. But we also think that such an interpretation conflicts with the declared aim of the legislator. And this was to create a comprehensive rule book for digital services with the DSA. And my last point, if we exclude all commercial practices towards consumers from the scope of the application of Article 25, we would not achieve the objective, the systematic objective of Article 25 to fill regulatory gaps. Mm-hmm. So that is why we don't read Article 25, paragraph 2 as an abstract exception. Yeah, maybe I leave it at that, and maybe I can come back why we don't think that the UCPD is not triggered in this dark pattern.
Okay, thank you. Thank you for explaining us this big issue regarding the interplay of these two legislations, because this is what I'm always struggling, how to differentiate and how to detect such practices from it's one or the other, right? It's a conflict of laws. So thank you. I have the honor now to present a renowned speaker, Katarzyna. Do you mind to pass me just?
Oh, yes. Sure.
Thank you so much.
Thank you.
To the next slide, please.
Thank you.
And here we have Katarzyna. You might be very well aware. It's a recurrent visitor and speaker and moderator at CPDP for several years. Is an activist, a lawyer, an expert in human rights and technology, and the head of the Panoptykon Foundation. Panoptykon issued several policy reports that are here in the slide if you are interested, both in 2023 and this year, specifically this one that is very interesting, Safe by Default. And these reports focus on dark patterns in recommender systems. Katarzyna, could you give us a few examples of dark patterns practices that Panoptykon found in recommender systems? And name them, please, explain them, please. What are the most prominent ones?
Mm-hmm. Thank you. Thank you for a very kind introduction. Indeed, we focus on recommender systems as something we perceive that is crucial design layer of very large online platforms that has a lot of power in determining how we find information, how we interact with content, how we interact with other humans online, and eventually how we feel and how we think. So that's why our choice to zoom in on this specific element of large platforms. Cristiana already kicked us off by showing Article 25, and Martin explained why it's so problematic in applying. Therefore, in our thinking how to force very large online platforms to change the functioning of their recommender systems, we thought of using one more provision that I want to quickly introduce. That is Article 34 on risk assessments. When you read it, it says, among other things, that VLOPs are obliged to identify, analyze, assess any systemic risk stemming from the design and functioning of their service, including specifically algorithmic systems. They are mentioned in this article. And in this risk assessment, they should look at, among others, serious negative consequences to the person's physical and mental well-being. So we are actually brought back to what dark patterns often do. But the problem here is that you need to prove the harm. You cannot just go to the commission and say, hey, we have seen that Meta, TikTok, Google, whoever there is, has this negative impact, do something about their recommender system. We need to work on proving the causality between how these systems are designed and the harms that are experienced by humans using these services. There is a lot to say about these harms. I'm sure our expert audience needs no introduction to vast research on that topic. But if you look through this research, as we have done in Panoptykon, searching for the arguments on causality, it's not obvious. I mean, we do not have strong evidence very often to show that specific design feature is causing the harm. We need to prove to trigger investigation by the commission. But some traces of oh, that has moved. It was formatted, I promise. Some traces of these links between specific design features and harms can be found. I will not take you through 100 papers we went through in our research. The papers Cristiana presented are an overview of that, but I just have a few excerpts from that research for you today to show that we are making big arguments, like very serious complaints about these systems, because we believe that this is the way to really get the commission to be interested. If we just continue saying that notifications are the problem, the default setting that optimize engagement of a user are a problem without proving harms, we have much less chance to make commission move towards enforcement of the DSAs. I think right now the real stake is finding evidence that shows the causality here. There is really a lot to revise. If you are one of the people working on research that looks at these harms experienced by minors or adults online with regard to their well-being, compulsive behavior, difficult mental states through which people go when they use too much of social media, and we argue they use too much of social media for reasons that owners of these platforms are very well aware of. So the argument here is that there is this higher frequency of social media use does not come from, free choice of a consumer to spend their life scrolling and getting depressed or getting anxious or getting disinformed. It is actually these systems are designed to cause that form of compulsive behavior and develop this pattern of checking social media apps even 150 times a day. That's the data we have. So our argument after revising all these papers we looked at was that indeed there is, we argue that there is a link between the design of social media recommender systems, specifically content curation algorithm, and the interface, which includes default notifications, dragging people into these machines, and the content curation algorithm being optimized for engagement, which means that the moment the machine spots a pattern in your behavior, spots what triggers your attention, what triggers your reaction, you will be receiving more of that content. And it is engagement by design. And engagement, as we see in the reports I mentioned, but there are really hundreds of them, leads to various types of negative effects on well-being, physical and mental well-being of minors in particular, but also adults. So that's the argument we are making, and we expect the Commission to do something about that. But yeah, summarizing the features, because you asked me which is like our short list of things we would like to disappear from very large online platforms. It's pretty ambitious. As you can see, it would be very different ecosystem if we get rid of these design features. We are probably talking about a different business model as well, but our argument is that it shouldn't be something to worry for us. These companies have made enough money to tax themselves right now and to protect humans and society from well-identified harms. So these are the features we've been looking at. And there's one specific that I want to draw your attention, because there was a case study we did as Panoptykon specifically on that. For the lack of better term, we call it fake negative feedback button. Fake because it deceives the consumer, it deceives the user with regard to the outcome of clicking it. Mm-hmm. We did our case study using Facebook, Meta's platform, last year. And it's not the first time we did that experiment, or case study actually. It's not experiment because it cannot be repeated. It requires specific user with vulnerability. We happen to have a real person with vulnerability using Facebook and being concerned about recommendations she's getting. And that person, supervised by the researcher we hired, Piotr Sapieżyński, she engaged a lot with the negative feedback button to see whether, as a result of saying, I don't want to see that content, her situation, meaning being exposed to content that triggered her anxiety, would change. Surprise, surprise, the result was the opposite. So the system identified her clicking the feedback button as engagement, and after some time, she was fed even more of the triggering content. Which is exactly the recipe to keep people in what researchers call doom scrolling traps or rabbit holes, which can have, in some circumstances, it can have a very negative impact on well-being. And this is not a problem we can solve with content moderation, because we are not talking illegal or objectively harmful content. We are talking about a situation in which specific user is triggered by some type of content which can be innocent and benign and completely neutral for any other person. But that user we are thinking about, in our opinion, should have the right, the mechanism to get out of the rabbit hole and feel protected. And if the negative feedback button is created, is there in the interface, but does not work, this is exactly what we would call deceptive design, and we should remove it. If not with Article 25, which may fail us here, definitely with Article 34 and 35 that refer to risk assessment and risk mitigation. What can be done? I mean, a lot can be done, of course, and people who design these systems, they know exactly how to design them to avoid these harmful effects. We've been through this process as well. We've done some prototyping with our group of colleagues from across the network. So we also invited designers. We also invited people who have experience with recommender systems, like Integrity Institute colleagues, to help us prototype features that go exactly against the direction I was showing so far. And what is key here is, and maybe not very intuitive for designers, is that it's all about removing frictionless experience. Frictionless experience is supposed to be something nice, right? I think this is how it's sold to us. Frictionless meaning good. In fact, we argue in social media, we need friction. We need to go backwards because people got trapped into this compulsive behavior pattern. They got addicted. They got deep in rabbit holes. They got deep in a habit of using social media the way they maybe never would have chosen if anybody asked them. So we need to add friction to make them stop and reflect. We are not fans of banning the use of social media for adults and maybe even minors. It would be complicated at that point. So introducing not flexible at all limitations in terms of time you can spend, all kinds of top-down measures. I don't think they will play out in real life where people are addicted to these services and they rely on these services for many functions. We might criticize that, but this is how the world outside of this room looks like. So we are thinking about positive friction, which is not there to destroy that experience for people who really want that, but help them reflect.
In the HCI community, several proposals for friction design can actually be interpreted as deceptive design per se. Instead of being reflexive, it can just, when the user wants to act quicker and the friction is held there, it can also be counterproducent for a user. Are your friction-based experiments being tested with users to understand what is the effect?
We do not experiment with them because we are not a UX company and we are not a VLOP. We don't have user-based to experiment with. The suggestions that are on this list of positive friction, they come from the work of people who, like Integrity Institute and others, who mainly former designers who worked with these companies, left, like Frances Hogan or Tristan Harris, and they became advocates of friction, adding friction to prevent positive friction. So we quote their work in our work, and we suggest to the Commission that the Commission should strongly suggest to VLOPs that they start testing it. So indeed, this is something that I think the companies have to test because they have the user base, they have the machines to test and see what happens. And it's not friction to irritate, it's friction to make people more aware of what's going on, to break the habit of sharing too quickly, sharing without reading what you share, sharing stuff that maybe you don't endorse, but you just compulsively share because that's how you reward your brain with another influx of dopamine. So it's meant to help in these situations. A couple of examples, we prototyped onboarding screen. You open it up, and first thing you see is this. What are you here for? Because maybe you are here for procrastination, or maybe you are here because you forgot you wanted to do something else. Maybe you wanted to do shopping online, or just check a message from your child and you start scrolling. So if that's the case, maybe it's better you leave. And if you really, really want to use this app today for the 15th time, maybe you can choose your feed. This is something we advocate for, and it's a topic outside of this panel, but I will cover it tomorrow in the panel we organize. So I already invite you to the panel on recommender systems not driven by engagement, designed to provide quality and quality experience for the user. How we do that? We think the way to do that is to provide alternative feeds, but not just two alternatives that we know already that they exist, so chronological feed or algorithmic feed designed by the company. There should be a third way where we design our feed, and if I go and I choose my feed, the one I designed, I don't get engaged so much. So this little tricks, and that's the final thing I want to show, which is a working, a real feedback button that really gives you control over the content that will be recommended in the future. So these are our proposals, and I hope one day they get tested. Thank you.
Thank you so much, Katarzyna, for explaining us different practices of recommender systems, dark patterns, and also risk mitigation measures. You mentioned something very interesting about measuring harms, identifying and providing evidence of harms. I would love to have a panel only for that, because I'm working exactly on which harms are caused or triggered by dark patterns and how to measure them, not only from GDPR, but also from a competition and from a consumer side, because the requirements to analyze these harms are very different per legal domain, but we should speak about it in a different session. I have now the pleasure to introduce you to Jeremy Bonan, representing here the regulatory side. Jeremy is a Deputy Director for Online Platforms at ARCOM, and ARCOM is actually a regulator for media and digital, media and digital communications in France. And ARCOM is actually the DSCs, and actually tomorrow will be the dedicated DSCs to enforce the DSA. I have a couple of questions for you. In what consists the role of ARCOM in monitoring and enforcing Article 25 of the DSA?
Yeah, thank you. Hello, everyone. So I'm the Deputy Director for Online Platform, which is the directorate at ARCOM that is responsible for enforcing the DSA and also the topic regarding protection of minors online. ARCOM is a new regulator. It's made from the old former audiovisual regulator, media regulator, and from the Anti-Piracy Agency in France. And it was created 3 years ago now to look forward to digital regulation of contents. So tomorrow, the law was published today in the official journal of French Republic. So tomorrow, ARCOM will finally be designated as the French Digital Services Coordinator. That is the regulator of the national regulator of the DSA. But it's not, we are not only a regulator, we will be, but we're also an enabler of civil society and academics, and I'll come back to that. We won't be alone doing the DSA regulation in France. There are 2 other competent authorities. That is the French DPA, CNIL, which is there, regarding the articles or sub-articles related to protection of data, and also the DG CCRF, which is the ministerial department responsible for consumer protections. And regarding specifically to Article 25, ARCOM will be responsible for Article 25, but for the marketplaces. So only the DGCCRF, the Consumer Protection Authority, will be responsible for dark patterns on marketplaces. So you directly pointed to the question, how do we articulate dark patterns in GDPR? Dark patterns
exactly.
As UCPD.
What are the challenges to articulate with all these different regulators in one member state and also with the other regulatory bodies in other member states regarding this article?
It's a good example to embrace the understanding of why we are a coordinator and not a regulator only. The role of ARCOM and DSCs in every member state will be to coordinate with other competent authorities to run the DSA, but also other ministerial departments that don't know how to deal with online platforms, and we think that the DSA brings tools to do public policies on online platforms, not trying to reproduce national laws that go against European laws, but using the tools, and we will have to explain how you can use the tools provided by the DSA to do the things that the health ministry wants to do. Let's say they have an issue with food habits that are being promoted on online platforms. They can come to us, you can explain how the DSA works, and we can maybe bring cases to the European Commission through the board of DSCs to make a case regarding systemic risks on very large online platforms. That's the way we think about it. And the same way we're going to have to coordinate between DSCs within the board. We have to coordinate within our own national states with other competent authorities. So let's say there is an issue regarding the dark patterns. We're the new kid in town. We don't have dark patterns in our legislation until tomorrow. But we will be working with our friends from CNIL and from the ministerial departments. Let's say there is this issue. Maybe we agree there is an issue. And then we can discuss all together to say if it's better to see if it's better to deal with it through GDPR or through UCPD, or maybe using the DSA tools. So that's the way we are, and we are thinking about dealing with dark patterns tomorrow. We don't have prejudices or pre-thoughts. And the other thing I was saying, that we see ourselves as an enabler, and the DSA leaves lots of room for the civil society, so through trusting flagging. And we will be giving trusted flagger statuses through the DSA in France for French-based wannabe trusted flaggers, if they meet the criteria. We will be helping academics to access data of the very large online platforms. So we can help, let's say, French-based academics to ask the Irish DSC to access data of Irish-based very large online platforms. So we can gather data to make research. The criteria is that it has to be linked to checking whether the DSA is implemented correctly by the player. So we think, well, there are the big ones, the very large online platforms. We will remain. You can recruit as many civil servants as you want. We will be always smaller than the online platforms. So we think we need to build on civil societies and the knowledge of everyone to be able
researchers,
to
for example, right?
And researchers that could access data in a better way than they do today with scrapping and not very useful tools, or the CrowdTangles was shut down. So now there is an access guaranteed by the DSA, so that academics can access data of very large online platforms. And we think it's a very strong feature of the DSA to enforce and ensure the good enforcement of regulation.
Thank you so much. That triggers me another question, but I will leave it for the discussion. I have now the pleasure to introduce you to our last panelist, Nataliia Bielova, and I would like you to give me the exactly, because I have a special slide for each of you. And Nataliia Bielova is a research scientist at Inria, with whom I've been having the honor to work since the last 5 years, and to whom I owe a lot, because I know more about privacy and data protection because I work with this computer scientist. Nataliia, you have done research on online tracking and on dark patterns, both from legal and technical perspectives. In which systems did you identify dark patterns that could be subsumed into Article 25.1 of the DSA?
So thank you very much, Cristiana, for this question. So I want to guide you through actually one example of a website so that I can show what kind of findings we have. So let's imagine we go on the web and we see this type of website, like a very basic e-commerce website. So when the regulators are looking into this space and they are trying to understand how to audit compliance, the typical view they are taking are the view of us end users, right? So what happens here is that we have analysis done on the behaviors of various services or websites or mobile applications. And the regulators are also looking into, of course, advertising ecosystem and all the tracking ecosystem, and who are all these players and what are they doing. And so this is the usual, from my understanding, view on the compliance auditing. But if we actually look behind the scenes of these simple websites like this one, we see that there are a lot of different content that gets loaded when we visit this website. Many of you have heard about this, but I think it's nice to remind how complex is this system. And actually, some of these companies are participating even in the real-time bidding process, where we know that the user's data is shared with many different servers, DSPs and SSPs, for those of you who are familiar with this. Anyway, in the end of the day, we have the ads delivered to the page, and all of this is very complex. So if when the regulators are looking into this, what we can observe from the outside and what we do also in our research team, We are looking at all these various requests and responses. And for example, on this website, we have 48 different cookies, and there are many other tracking technologies that are present there. So this is not new. This is quite known. It's yet very complex. It's still very difficult to regulate. But we decided to actually stop here, pause for a minute, and say, hey, but how were these websites built? Right? Somebody has put all this content in there. So what kind of decisions the developers were making when they were combining all these various tools and services in their website? And maybe were they exposed to dark patterns? So how did they reason about including this content? So in my team, we decided to take a different view on this and say, let's have a look at the service owners, right? So what do they see when they are building their websites? And we actually found that, well, there are, if I simplify, there are two big kind of type of companies. So there are advertising and tracking companies. And there are also other type of tools that are called tag managers. How many of you have heard about tag managers? Okay. Right, so these are the tools that are actually there to help website developers to build the websites and to combine various advertising and tracking scripts, so programs, easily on their website. So we decided to take a bit closer look at the installation process of these various tools. So when we looked at advertising and tracking companies, I will show you a few examples here because we don't have time to go through all of that. But we looked at Google Analytics. How many of you heard about Google Analytics? Oh, nice. Oh, great. OK. Yeah, so what happens when you as a website owner want to install Google Analytics? Well, actually, you have to go through a number of interfaces. So you are exposed, again, to certain interfaces. You have to make choices. And one of the interfaces in Google Analytics is this one. Can we spot a dark pattern here? Well, actually, yeah. So there are already predefined enhanced measurement enabled by default. So these are bad defaults that are there in Google Analytics facing the website owners. And we even map it to the ontology of dark patterns to try to give it a proper name. So bad defaults, and second one is sneaking, where the information is further hidden. Actually, if you click on those +4, you will see what kind of more information is there. And if you click on a little strange settings kind of icon, which doesn't look like an icon, apparently more things show up. You can actually see more. So there is a hidden transparency, but it's really hidden. OK, so that's one example that we found. We have also looked at other systems like tag managers, as I said, that help to basically customize your website and bring in all these different advertising and tracking tools. So we had a look at that too. And we found out that through the installation process of this type of tools, we also see a certain type of dark patterns. I know it's not easy to spot, but basically this kind of interface shows first all the kind of tools that Google is offering himself, and only when we click on this strange blue, so the upper box in the figure, then actually we have access to all the other services provided by all the other companies. So this is a very typical example of self-preferencing. So maybe the competition law here also would make some difference. I don't know. But these are the kind of examples we have found that we believe are actually problematic. And so our research doesn't stop there, but I just picked something that is quite visual for you to see.
Thank you very much for these examples on Google Analytics and Google Tag Manager. You have worked at the CNIL for at least 1 year regarding, and what is your experience and your know-how in demonstrating the impact of dark patterns on the user's decision-making?
Mm-hmm.
Yep, I think we need to
all right, okay, yeah, okay. Yeah, so I think, so just to summarize briefly on the application of the Article 25 DSA for this kind of examples, I think this is...
Let me just give you an introduction to this aspect.
Right.
Article 25, number 1, applies to online platforms which manipulates the recipients, right? The recipients of the service, which can be, again, users, end users, or business users. And so how to understand who are the recipients within very complex systems like GTM, like Google Analytics? Because normally we are used to see only the end users, the consumers, being manipulated. But then there's maybe middlemen also being manipulated. And I believe that our work on GTM and Google Analytics brings a different perspective into different users being manipulated. Could you give us a little a hint, but very short because of time?
So very shortly, I think that the Article 25 should apply to this type of systems because it's a business-to-business relationship. But the problem is the definition of online platforms, because it has this very specific framing about the content that's disseminated to the public and provided. So, I mean, maybe for some systems this works. For tag managers, we hope it will work. But for Google Analytics, it doesn't. So I think, in my view, this article is very restrictive when it applies only to online platforms. So some of these cases that we have found will probably not be covered because of that.
Maybe by other regulations, like platform-to-business regulation, and potentially from a more wider interpretation of this Article 25 by the Commission, which we hope to nudge the Commission on that more broader interpretation, hopefully.
I'll skip through. Okay.
So, yes, tell us a little bit more about how to demonstrate this impact on users' decisions, on these recipients of the service, specifically based on your experience with the CNIL.
Yeah, so when I was at the CNIL, we have run a project when we decided to evaluate and measure the impact of various designs of cookie banners, in our case, on the user's decision-making. So we have tested 6 different banners. I don't show you all, I show you only 3 here, just to make it brief. And we had around 4,000 people in France who have participated in our online experiment. So what's interesting about this project is that we tried, of course, to include very basic dark patterns, like the one you see in the middle, where it's very typical, where the decline button is hidden on the second layer, of course. But we also have added some, I think it refers to Katarzyna's word of friction. So we included some changes in the typical banner design that users don't expect. So the previous research shows that users don't actually read the banner text. They don't. They just look at the buttons. So we decided to add consequences of their decisions, of their choices inside the buttons text, so that hopefully they pause for a minute and they think, what are they going to click? And, well, the experiment was very successful because we found out, sorry, I have to go back. Right. Yeah, so we found out that when users are interacting with the neutral, a standard banner that you see here in control in the middle, the refusal rate is what you see here. So refusal rate of the users is 17%, but when they interact with other banners, like the one that I show you in red here, so the consequences banner, where the choices are, the consequences are presented clearly, the refusal rate goes very high to 47%. So this is huge. And we also have statistical tests to show that this difference is really impactful on the users. So we believe that these kind of banners can be a nice example of a friction where that helps users to stop and think, and at the same time their decisions will be changed quite a lot. Another experiment we have done within the same project was about evaluating how much the dark patterns actually affect the user's decisions in the future. So when people are continuously exposed to these dark patterns, does it change their way of thinking or not? So we have actually collaborated with behavioral economists who told us that it's enough to expose a user 2 times to something to observe a change in their behavior. So that's what we did. We have actually showed to the users 2 times a very specific banner that we were testing. And on the 3rd time, we would be showing them the control banner. So just I accept, I reject, very basic control group, right? Well, If there is no effect, we would observe that their refusal rate is the same across all these groups, right? So we have now evaluated the refusal rate here. So of course, you expect that the results, of course, are not the same for different groups. We found out that even two exposures to dark patterns already changes their decision making. For example, when people saw 2 times the very bad dark pattern where there is no refusal, and then we show them a neutral banner where there is accept and refuse, the refusal rate goes from 19 to 10%. That's huge. And we had exactly a similar scenario where we looked at the opposite, so at the banner that shows the consequences, and we found out that this already changes their decision again on the other direction, so from 19% refusal to 36%. So some people might say, well, it's just a very short-term effect. We don't know how it lasts. Well, the answer is on the internet today, the effect is going on every day because we are exposed to dark patterns all the time. And I think this type of experiments can be extremely useful as evidence. If we actually test it with users, we have proper academic methods, we have statistical tests, and this can help a lot. Just to conclude, I think there are other methods. So there are, of course, online experiments, but there are also other techniques that can be used. So for example, right now, we are setting up a new collaboration with the experts on brain-computer interfaces. And we can use other tools like eye tracking and the pupil dilatation, and we can even imagine something like EEGs, where we can make experiments with people and see what kind of effects it makes on their, for example, on their cognitive efforts. And of course, we need to have collaboration across many different fields in order to address their patterns.
Thank you, Nataliia. Before launching the questions from the audience, I would like to pose a question again to the panel. Feel free to whoever wants to answer. So we have discussed several mitigation measures according to Article 35 of the DSA and with regard to the design of online platforms. And we have also discussed several other online platforms, not designated yet by the Commission, but that fulfill the requirements of online platforms. In which way would you recommend the European Commission regarding the enforcement of Article 25, number 1, according to your technical, civil society, regulatory, and policy-making expertises? Feel free to bring it up. In which way would you additionally advise the European Commission regarding the enforcement of Article 25?
I can break the ice if you want to. Maybe just to illustrate one of the, I think, most interesting feature of the DSA overall, it's an asymmetric regulation. So it distinguishes obligation whether you are a very large or a basic platform. And I think it's a proof that we learned from other digital regulation in Europe that you need to have a risk assessment and you put your effort on the bigger players to have a larger impact. So I think one way to keep this feature alive, it's up to the Commission to set the tone with the inquiries it opened against the very large online platforms. It's going to use, it can both use a specific obligation to very large online platforms, but also the basic obligations against them. So especially Article 25, it's a basic obligation. And so while enforcing the DSA with very large online platform, the Commission will set the tone of what we can do and expect from the DSA on smaller platforms.
On smaller platforms, okay, thank you. Does anybody in the panel wants to build on Jeremy's arguments?
Well, I can add that obviously it would be great to have guidelines issued that the Commission
we are looking for them.
Can issue under Article 25, and maybe through that bring some more light into interpretation of this provision. Everybody who has been close to the DSA negotiations remembers that that article did not include this reference to previous legislation until trilogue. And it was introduced, that reference to GDPR and UCPD that gives us so much headache was introduced by the Commission specifically, who is the guardian of the consistency among laws, and I respect that. But at the same time, hey, we are looking at obvious examples of dark patterns. 2024, GDPR having more than 6 years, UCPD, I don't know because I'm not working on that, but I guess twice or 3 times longer. Something is not okay, something is rotten in the Kingdom of Denmark, we have to face it. So just referring to these old laws that have failed us so dramatically is not the answer. So for me, the Commission should show more activism with the guidelines. But it has other provisions. It has risk assessment, risk mitigation. It can investigate exactly the way it investigates Meta, Pay or OK. There is nothing stopping them from doing that. It doesn't have to justify, oh, we are using GDPR. Oh, sorry, no, now it's DSA. They can just move on and enforce. And their lawyers, I'm confident, they're very clever people in the Commission, will find the legal basis. So I would just say enforce. And if that doesn't work, if the Commission itself notices that there is no strong legal basis for attacking some of these practices, then it should listen carefully to what BEUC says. We will have BEUC on the panel tomorrow, and I'm sure there is more BEUC panels happening during this conference. They came up with this idea of Digital Fairness Act as something that should result from the fitness check conducted by the Commission in this term, fitness check of the consumer law. So the argument here is that we have to upgrade some of the principles, rethink maybe some of the principles of the consumer law because of this digital asymmetry situation, because of how deeply manipulated consumers are online. So it's almost like changing the paradigm from pretending that we are rational creatures doing transactions and sometimes deceived. The idea here is to acknowledge that we are deceived, manipulated, forced into action that is not good for us all the time. And therefore, the protection has to be much higher, much more aggressive in a way.
So we had a lot of hopes for the DSA, but now we understand the scope is either broad or, as Martin said, quite encompassing. Broader at least regarding the high threshold of the UCPD. And now we have our hopes translated into this Digital Fairness Act. So our hopes will continue. Let's hear the audience. Does anybody at the audience have any questions that you would like to pose to our panel? And if you do so, please identify yourself first and then pose your question. Do we have any brave voice? Yes. Yes, we have.
Thank you for this very interesting presentations. Using actually the opportunity, because no one else has a question so far, to ask a question to the regulator concerning something that was discussed by other participants, which is, I'm curious to know whether, in your opinion, or the opinion of ARCOM or other digital service coordinators, the DSA can apply to advertising platforms that take part in the programmatic advertisement space, because that might, whether the answer to that question can have a lot of effects on the actual effects on the DSA. So I'm curious to know what the reflection is right now among regulators. Thank you.
Do you wish to address this question to a concrete panelist or
well, either to Mr. Bonan, but maybe if other panelists have anything to add or have any element of answer, of course, it's up to you. Thank you.
Yeah, thank you. So if I remember well my regulation, my DSA, there is one recital that says that advertising platforms or repertory could be designated as platform. So it really depends on the way it works. And then I would have to have a France-based platforms to do the designation myself. So maybe if I find one and I have issue, I could bring the case to my counterpart, DSC, say, oh, look at these players. I think it's a platforms and there are issues. But yeah, it can. I think it can, yeah.
Thank you. Do you have any other question? I saw some arm raised there.
Thank you. Very broad question, so it might not have an answer. Apologies, but it jumps off a point that Kasia made. The question of causality and the need to sort of demonstrate causality. And at the moment, Jonathan Haidt, as many of you will know, has a recent, very controversial book out about the effects of social media on children's mental health. And one of the massive debates about this book is that he is going through a lot of academic literature, and a lot of academics are responding saying, yes, you went through all that literature, but it's still really hard to prove causality. Even with hundreds and hundreds of papers, it's really, really hard to prove causality. So how do we operate in this world where causality is so important, but at the same time, almost impossible to prove in these circumstances?
Very good question.
We take risks. I mean, the companies, on the other hand, they are not waiting for permission. They are moving fast, breaking things. That's how they build their data power and their attention exploiting machines. So maybe it's just time for us to be, for us meaning, the Commission, supporting experts, researchers, also become more aggressive, and sometimes even say things that we cannot prove, because proving them without being inside these machines is terribly difficult. But if you make it at least probable that the harm exists and it's linked somehow to the design of the system, then I hope we push the burden of proof to them. So they will counterattack. They will come and say, no, it's not true. But that's the beginning of a dialogue. And with other mechanisms that the Commission has, investigations that can go really, really deep inside of the companies, but also our vetted researchers' access to data, then maybe we can continue that conversation. But if we stop ourselves from even starting it because we are not academically 100% bulletproof, confident of causality, then they will keep winning by just moving on.
Just to add a note on this, yes, it is very hard to analyze the causality, to check the nexus between the practice and the harm, but also it depends on several other measurements, parameters to assess harm or adverse consequences. So actually part of a robust risk assessment depends on the measurable, objective and subjective parameters to quantify harms, but actually the most challenging one are the non-material harms, the psychological harms that we were talking about, the privacy harms, autonomy harms, discrimination harms. But we are building on objective and quantified parameters to address that difficulty. When we are discussing with other policymakers on how to build a legal framework, a sound one, based on objective criteria and measurable ones, to tackle these non-material harms, which are the most difficult to consider. We have space for one last question. Who is the brave voice that would like to address the panel?
Hi, my name is Konstantin Gisler. I speak for .Europe, which is a trade association that represents a number of these platforms that you just described in some of the examples. Sort of like one little comment and one question. I think one thing that didn't really come up was materiality. What's actually the threshold? So I think it's also really important for companies, and that's why we're also eagerly waiting for the guidelines, to know what can we do, what can we not do. I've seen the examples, for example, with collars. During the DSA debate, there was a lot of discussion around that slogan, what is illegal offline is illegal online. We see red ink in supermarkets, big signs, small signs sometimes. So there's a lot of stuff that is pretty common already in the offline world. We're sometimes wondering, now, just because I'm making a button yellow, is that more dark than red? Is it more dark than green? I think sometimes it's also hard to navigate for the companies. And since the article actually says it needs to materially manipulate or distort or impair, where's the threshold so that companies also have some guidance? And the last one, maybe a little sneaky comment, the solution here that was presented, I think, by Ms. Bielova, in the end is actually then also a dark pattern. If you reduce the choices to something that is trace me, don't trace me, it's actually an oversimplification, which in a way is also a manipulation, even from your perspective, of course, a positive nudging. but it's actually maybe even also against the article.
Regarding the first question on the materiality, actually materiality is the severity of the practice, right? And unfortunately, we are waiting for the guidelines, but there are quite empirical and legal research about the severity of certain dark patterns practices. Does anybody in the panel would like to address the requirement of materiality, which is just putting the DSA for us, all these different stakeholders to interpret at our own risk?
I have only a very long answer to this. And
There's a break.
we can talk about it because that's what I am thinking of as well. So that's a big issue for me as well, and it really gets to a point between the interplay between Article 25 and the UCPD, which is for us from legal perspective very important, and for you from your perspective as well. But I don't know if I should start to answer this question. So maybe very, very brief. How to make use of Article 25. Our legal approach is that the GDPR and the UCPD, in a way, they have the more specific requirements. And these have to be checked first. So first you have to look at the GDPR and the UCPD. But then, on the other hand, you have Article 25. And Article 25 should only apply if the dark pattern does not fully comply with the GDPR and the UCPD. It's a kind of fallback provision, It's a complementary provision. Again, when comes Article 25 into play? From our point of view, Article 25 comes then into play when it does not, when UCPD does not fulfill completely the prohibition of when the case does not fulfill completely the prohibition of the UCPD. For example, if we look at our Temo example, we believe that in this example we can show that this is not a case of the UCPD, but it is a case of Article 25. Unfortunately, or fortunately, this case is settled because they
solved it. Yeah.
They gave the cease and desist letter. But we have other cases as well, and we try to move forward with this, with our interpretation. So at the end, we will see if this sticks. We don't know yet. But somehow we have to make use of the law that we have. We don't have any other law. And from our perspective, it's a big issue, this dark pattern issue. And it's not fully addressed with the UCPD and the GDPR, as we see, as you pointed out before.
Thanks for your question. Yeah. So I think the answer is that the neutral design doesn't really exist. And it depends on what we consider as a norm, right? So we have considered now that I accept and I reject is a norm. So every deviation from that would be seen as a nudging of some kind, right? But why do we have to take that as a norm? Why can't we take something else, something that actually explains to users what will happen to them when they click on that button? And that was the idea behind this. And actually, it was also backed up by the CNIL's own recommendation to say that the users need to know the consequences of their actions. And so we interpreted it very literally and say, okay, let's just put it in the button and see how this works. But your comment is correct. I mean, but we can say that about every design. Thanks.
I think the time is up for our panel. Thank you so much for our panelists.